So if you guys are good, we're going to flip over to our slides. I think Abigail's going to share her screen with you, and so let us know that you can see those. They might come in a little fuzzy at the beginning, but that's okay. Give them a second. The resolution just has a little bit to catch up, and they should be good to go. Okay. So Abigail is going to share her screen. Perfect. Okay. Welcome, welcome, you guys. We're so excited to have you. We know a lot of you have been asking for this workshop, and a lot of you send us questions all the time about needing copyrights or trademarks and trying to figure that out and protecting yourself, and we felt bad for not being able to provide you that information because we don't know. So we want to bring on the top-notch experts who actually know their stuff and who can protect you and give you great tips on the direction that you need to head. So you belong here, and you are so ready to hang out with us today, no matter where you are in your business journey. Even if you're just starting out and you think that maybe I should get out on the right foot and start this process super legit and protect all of my work from the get-go, you're going to learn a ton of stuff today. But maybe you've been in business for a while and you know that there's something more that you should probably be doing to protect your creations and your craft, right? So no matter where you are, you're going to learn some stuff today, and we're going to set you straight.
So guys, if you have tuned into either part of our series, you know that the whole point of the whole series is to give you the power and to make you feel like you have ownership in this. We want you to feel legit. We want you to feel professional. We want you to feel like you have the tools and the knowledge to be doing this the right way, instead of just like willy-nilly guessing or assuming that what you're doing is working and you don't need to be doing anything else. So we're here to give you the knowledge, and we're here to help you feel ready so that you can prevent things from happening, and so that you can protect yourself and your ideas and your work and your relationships, and you can be armed and not so dangerous because they're protected, right? All right, so we are excited you're here, and thank you all for coming.
So, babes, we know your excuses because we've made them too. We continue to make them. You're afraid that this whole legality system, no matter what it's addressing, contracts, copyrights, forming your business, anything, trademarks, you think that it's going to be super complicated, it's going to go way over your head, it's going to cost you too much money, it's going to take way too much of your time to figure it all out. So we get it. Just breathe that sigh of relief. We know that sometimes this jargon kind of gets a little bit in our head. I get it. I definitely get it. There's stuff that I kind of just zone out on that are aspects of our business. Anytime there's numbers brought into the game, I'm checking out. I'd rather be doing anything else. But trust us when we tell you, when you're taking your business seriously from the get-go, these are the things you really need to spend an hour on and pay attention to, because it can really, really, really set you up for success rather than failure.
Because at the end of the day, no matter what, the goal is for you to build a business, not a hobby. We love hobbies. Hobbies are fabulous, but they do not fuel an income that can help you and your family and let you feed your rescue doggies or feed your kids or, I don't know, buy that marble countertop you've always been dreaming of. The goal is to give you a business that like freaking rocks your socks off, so that you can do the things you want and live the life that you want. That is our goal, like 99.9% of the time. And as always, we want you to have fun. But seriously, it's going to be about starting today. Because whether you've been thinking about it for a long time, if this idea that you have is not yet started yet, we got you. We're going to help you build it into a business and take that idea and like run with it. So we're so excited for what you're going to learn today.
So what exactly are we learning today? You're going to learn the basics of intellectual property, trademark, and copyright. So we're going to take that headache out of all of this, and we're going to learn just what the heck are those things, what make them up, and how do you kind of bring them into your life. Like, seriously, before I've even learned this stuff from Christina, I don't even know the exact words to explain exactly what you're going to learn today because it goes that much over my head, or I feel like it's going to. But she's going to break it down super, super simple. We're also going to touch on what the heck to do if someone steals your idea. We know this comes up so much, especially in the creative industry. We're going to talk about not only what you should do, but what are your rights in using someone else's image or someone else's design or logo, and how can you try to protect yourself in that? So we're also touching on exactly what you need to actually license your work and get paid for it, and the right way to use copyrighted material in your own business. So exactly when does it make sense, how to protect yourself, how to respect the law and the rights of the other creative person of work you're using, and we're all boiling that down to figure out how to get started today, right now, so you can protect yourself from the get-go.
And as always, you can't miss the end. Guys, we're going to show you a guided way to legalize your business, including not only stuff we've covered here today, but in the past 2 awesome parts of this series, we're also giving you the best invitation in town to the coolest business club ever, and we are so happy to all be a part of it, and we really would look forward to joining you in. And as always, there's an exclusive VIP bonus, so wait for that. I am Abigail Pumphrey, the co-founder, brand, and business builder here at Think Creative Collective. I am also a flower enthusiast, which if you couldn't see my screen, I have some in my office as usual, and I'm a volunteer junkie. Emily Williams is my beautiful business partner. She's also a co-founder here, brand and business builder, and she's my local decaf coffee chugger and houseplant hoarder. She oxygenates the office. That's her job. She keeps the carbon out, you know, the important things in life. Christina is our beautiful guest here today. She is the attorney for creatives. So yes, ladies and gentlemen, she is an actual lawyer here to give you real legal advice. But she'll always give her disclaimer, so look forward to that. That's the best part of the whole webinar. So a little bit about Emily and myself. We got started just about a year ago on our own paths. I had my own business. She had her own business. I got laid off, actually, but I managed to replace my corporate income in 30 days, which was a really incredible journey. And I learned a whole bunch about business and what to do and what not to do and what worked and what didn't. And I found Emily and fell in love with her. She started her entrepreneurial journey super young, straight out of college. She submitted a lot of applications, and after a lot of, I don't know, lack of callback, she decided to open her own business, and she has been booming ever since. She's had a couple businesses since she started, but we joined forces last September, and we have together grown a community, which you're a part of, and we're so glad you are. We've been able to support both of us and our families in less than 1 year, and we're on target to double our income. We've got a happy and hustling group of members from all over the world in all sorts of industries, and we are so glad you are a part of it. So today our guest is Christina, and I will let her introduce herself.
Got to take myself off mute. Hey guys, I'm Christina. So yes, just as Abigail said, I am an attorney. I'm here in Georgia in the United States, for those of you who are maybe in Canada or the UK. And my background is in trademark law. So I'm really excited to talk to you guys today. I love trademarks. Trademarks are my favorite because trademarks have to do with your brand. And I know for a lot of you here, branding is a big deal. I think you know, a lot of us spend a lot of time looking at other people's brands and our own brands and things like that, and getting really excited about, you know, improving ours or creating ours, maybe if we're in the beginning stages. So I got here because I started out in my legal career, didn't really feel satisfied, you know, I was working corporate and didn't like it, and so I quit. And I did pretty much the most opposite thing that I could think of, I think, just as a big middle finger to my corporate career, and became a private yoga teacher. when that wasn't going so hot, I looked to things that I could do to improve my business. So just like you guys, I would go online and do things, and unfortunately there wasn't something like the Biz Chick Co-op. So I was just kind of piecing together contradictory advice all around the internet, which took me a very long time to figure out how to get to this point. So thank you, Abigail, and thank you, Emily, for making that a shortcut for everybody. And basically what I did was I started blogging and did my own graphic design, all that kind of stuff. And cool, Lisa. And anyway, so I started doing all this creative fun stuff, got involved in the Rising Tide when it came up, and then was introduced to Abigail, and then eventually Think Creative Collective when that became Think Creative Collective, and just never looked back. Decided to become an attorney for creatives. I thought that that was a need in the industry, and I knew that I could fill it, and I knew that I had a very unique angle, being that I started my own business. I started a couple of my own businesses that all were relatively in the creative field, graphic design, web stuff, and obviously the yoga. So I felt uniquely situated to take care of y'all, and I still do my own graphic design. Cover your ears, Emily, or Abigail. But I'm really excited today to talk to you guys about the legal aspects of what's called your intellectual property, which is a lot of what most of you create as photographers and graphic designers and bloggers and people that live online.
Awesome. So really, guys, at the end of the day, we all treat our business like a business because that's our job. This is what makes us income. This is what helps us build the life that we want, and we want you to do the same. So we are so happy you're here, and we are excited to get started. So,
all right, everybody's favorite part. I feel like I'd be a bad attorney, though, if I didn't just give you guys a quick disclaimer. Let me flip it on my screen so that y'all can, oh, sorry, guys, I didn't do the one-pager thing.
That's okay.
Okay. How's that look for everybody? Is that good?
Yeah, it looks good.
Okay. Do I need to adjust it?
I think you're good.
Okay. Okay. There we go. All right, I fixed it. Okay, so just because we're talking about legal stuff today, I want you guys to know that the stuff that you're saying in the comments isn't necessarily confidential. So make sure that if you have a specific question or something like that, that you wouldn't want someone knowing about, that you're just kind of generalizing and, that kind of thing. So basically what we're doing today is we're going through some of the more informational aspects of building the legal side of your business, specifically the intellectual property that your business, how we can take care of that intellectual property in your business. And what I'm telling you today is a lot of, I'm sharing a lot of knowledge, I'm sharing a lot of information that can help you get started. And obviously, in the Biz Chick Co-op, in the Biz Chick Co-op, you guys are going to go a little bit deeper into all this. So if this is touching on some issues for you, you might consider that investment, since this is only the tip of the iceberg today. And I'm not becoming your attorney by presenting this information. I'm really excited to share this with you. And if you do have any legal questions, make sure that you do reach out to an attorney. The really cool thing about IP law, really quickly, is that it is federally based, which means you can get an attorney from anywhere. You may have heard that you have to have an attorney from your jurisdiction or your state. That's not true when it comes to IP. So that's super exciting, you guys. Gives you lots of choices. Okay, so what is intellectual property, aka IP, and why should you even care about it? Intellectual property is made up of a couple different things. When we're talking about intellectual property, we're talking about trademarks. So those things that have the TM or the circle R symbol after them. You may have noticed on your favorite logos, on your favorite your favorite brands and packaging, you'll see that symbol, and it's usually after the company's name or some kind of tagline that they have. All of those things are trademarks, and we're going to talk a little bit more about what a trademark is. Intellectual property also encompasses copyrights, and a copyright is the circle C symbol that we see at the bottom of people's blogs and websites and photos and things like that. Copyrights obviously are attached to pieces of art. So photographs, graphic design, it's attached to things that we write. That's considered a form of art in some regards. So the copy on our website is copyrighted. The blog posts that we put out are copyrighted. The emails that we write to each other are copyrighted. So all of that is intellectual property. There's also some other kinds of intellectual property that we're going to talk about in just a second. But first, now that you know roughly what intellectual property is, let's dive a little bit deeper. Let's go a layer deeper. So trademarks. Trademarks, like I just said, they're my favorite thing in the world. I love trademark law. I love applying for trademarks, searching trademarks, branding, everything that happens with trademarks. And so what is a trademark? A lot of people have the misconception that a trademark is there to protect you as the business owner. And actually, trademark law was invented or created as the way it is today to protect consumers from confusion. And so what would happen is, an example of this is that you walk into, so this has actually happened to me. I've walked into a CVS before and I've gone to buy Benadryl, and I like to use, I'm a trademark attorney, I like the brand name of stuff, so I don't want to buy the generic. So I go to buy Benadryl and I grab the CVS. It's like the CVS drill or whatever. Walgreens has theirs. It's called Wall Drill. Maybe they changed the name, but and it's in that bright pink packaging. I think I've just grabbed Benadryl. I walk out of the store. I look in my bag. I see that I bought the generic version, and I'm like, oh, and I'm already out of the store, so I already have the generic. It's seriously, guys, this is like not a real problem. I'm just using it as an example. So in that case, I was a consumer and I was confused by the packaging, the logo, the trademarks on the CVS branded, the generic medication were substantially similar in my mind to that of Benadryl. So much so that just on the quick glance that I had, I just grabbed the wrong package and bought the wrong product. And so that's what trademark law is designed to protect. It's designed to protect the consumer from buying products that are otherwise inferior or worse in quality or somehow different from the trademarked product. So for example, you see this a lot with sodas like Coca-Cola. A lot of people want that good reputation that Coke has as a soda. I mean, relatively, work with me, guys. I know it's sugar water, but still. It's tasty sugar water for a lot of people. I'm here in Atlanta, so Coke's king. I grew up in a Pepsi house, though, so. Anyway, so they want whatever. They want that Coke, they want that Pepsi, and so what they do, they want their consumers to associate their new soda with Coke or with Pepsi's quality or reputation, and so they'll create, and you may have seen this before, like Sam's Club or something like that will go out and they'll create the generic version, and it looks really, really similar to Coke or to Pepsi. And you might even be confused and purchase the generic Sam's Club version, and then when you go to taste it, it obviously tastes different. And so that's trademark law is designed to help prevent those situations from happening. And what that means is that when you have your name, so Christina Scalera Photography, someone else comes along and they register the trademark Christina Scalia Photography, and they think you have consumers now coming to your website trying to buy Christina Scalia's images. That's the kind of confusion here that a trademark registration is designed to prevent. So that, if you have, for example, I'm just making this up, you're a calligrapher, let's say, and you have blue and ink design. I have no idea. Maybe that's someone's name. I'm sorry if it is. I just made that up. So blue and ink design. And there you become this big famous calligrapher. They have all these great products. And you have let's just call it a different company. So a different company comes along, and they're called Green and Ink Design. If consumers are starting to go to Green and Ink, thinking that they're going to Blue and Ink, that's a problem. And so at that point, if Blue and Ink has a registered trademark, they can then approach Green and Ink and say, hey, this is our trademark. You guys are confusing our consumers. We're losing consumers to you. Stop. And we'll talk about how you actually do that a little bit later in the presentation. So that's what a trademark is. A trademark, essentially, all it boils down to is what's called a source identifier. All it's doing is identifying the source of products or services. And so we don't want the consumers to confuse the source. We don't want consumers to buy the Sam's Club cola and think that they're buying Coca-Cola. That's the purpose and the point of trademarks. Okay, so how do you get a trademark? This is a question that I get all the time. Unfortunately, this is something that you really need to think long and hard about doing yourself, and I never recommend that someone that doesn't have even attorneys, I don't recommend that if you don't have a background in trademark law that you apply for one on your own. And that's because the government fees start at $225 for a regular registration, and you don't get those fees back. So you might, if you try to do it on your own, you may end up spending just as much as you would with an attorney, and still not even get the correct registration in the end. So it's really important that if you are serious about getting your trademark registered, and what that means is registering it with the federal government, with the United States Patent and Trademark Office, that you find an attorney that specializes in trademark law to register that for you. And so the best way to do that is to start budgeting for that in your business plan. The reason why you want a federal registration is because it puts everybody else on notice that that is your name and they cannot use it, or that is your logo and they can't use it, or that is your whatever design mark, or that's your tagline, something like that. So you're just letting everybody else out there know that not only is this your company name and you're using it, obviously you have your website already, but once that federal registration, once that trademark is issued to you, they can then also, that's a public database that they can search and they can find and see that oh, okay, this name is already taken. I should probably come up with something different, or they could potentially sue me. So it's really important to, if that's something that's important to you, if having your name, and we're getting to this now, when is it the right time to get a trademark registered? If having your name is super important to you, like if this is like a family name or a family business, or you just are in love with your name, you couldn't even fathom rebranding or fathom changing your name or something like that, that's when it's time to start looking into getting your trademark registered. A lot of people are really interested in getting their trademark registered without much thought ahead of time, and so maybe they haven't started selling anything yet, and there's definitely a trademark registration available. It's called an intent to use application. It's something that you can get if you haven't started selling yet, so that's also an option if you come up with a name and you don't want someone to take that in the meantime. Otherwise, you are already acquiring rights in your name or your logo, your tagline, whatever it is that is your source identifier of your company, as soon as you start using it. So as soon as you start using the tagline, like my tagline is creative, period, attorney, period. And I'm already acquiring rights in that as a trademark for my business. So that's one example of something that I haven't registered yet. I might think about that soon, but that's something that I'm already acquiring some kind of right to use in. And so that's when you really need to start to think about registration. And cost is also a concern. So if you aren't ready yet to budget for a trademark registration, then if you're just getting your business up and started, or you've never started a business before, I'd say it's probably a bad time to think about a trademark registration. You have other things that are more important to spend money on, that are more important to budget for. And to be quite honest, like from a business perspective, this is an illegal thing, but you can always come up with a different name. So that being said, everybody always asks, how much does a trademark cost to get registered? It really depends on the attorney you use. I'll just tell you guys right now, I charge almost $1,400 to register a trademark. And that is because there's a lot of search costs that go into that. So I have to figure out where other substantially similar marks exist, if they exist. And that's done through Google searches, obviously, and through various commercial outlets, even Facebook, and then obviously the United States Patent and Trademark Office has a search database that we go through and quite meticulously look at. So that's where it starts. And then after, let me just walk you through the client's process. So once a client comes on and we've engaged, I'm now their trademark attorney, they'll tell me what mark they have. I send them a questionnaire and they get that. And then we do the search for them. I have a consultation and I advise whether to proceed with the registration or not, because sometimes when we're searching these marks, we find things and they come up, and there are red flags that come up. Basically, there's other marks that are too close or the same or something like that, and I don't think that a registration will be issued at that point. And so I advise the client to move forward or not. And then I go ahead and prepare the application. So preparing the application, I don't want to get too boring with you guys, but that involves a lot of different legal steps, and that's where my background in trademark law comes in quite extensively, like preparing that application from start to finish and making sure that everything's correct, and then obviously eventually filing that with the USPTO, the United States Patent and Trademark Office. So that's kind of how the process works. That's what it looks like. And that's how much it costs. The good news is, like I said, you're already acquiring rights. They may just be limited to your area. So if you are in Northern California and you're using a name, someone else in Florida comes up with the same name and they start to register it, you will still have rights in Northern California if you were the first user typically. But after that federal registration is issued to the person in Florida, if you haven't said that you're aware of it and you oppose it or you file it on your own or something like that, at that point, you can't use that name if you decide to move to whatever, Georgia or Florida or whatever, and you move your business there. So you'll have to find a new name at that point. So that's another benefit of registering your trademark. So then we have copyrights, and copyrights are awesome because they are fixed at the moment the work is created. So what that means is that as soon as you write that blog post, even if you haven't hit publish yet, you actually have a copyright in that material. As soon as you take that photograph, even if you haven't uploaded it to Lightroom and edited it yet, you own the copyright in that photograph. So that's really significant because that's really easy to get a copyright. I mean, you just do what you're already doing and you have a copyright. So that's the great thing about copyright law. The other thing about copyrights that I love is that you can actually apply for a registration on your own. This is something that you don't need a legal background for. And then the third thing I love about copyrights is that this application costs basically nothing. You can register a whole collection of works for $55 with the Copyright Office. So what that means is, if you're a photographer and you have like a whole wedding and you want to register that as a collection, you can do that. If you're I have a client that's a surface pattern designer, so she designs fabric and like the covers of binders and covers of notebooks and things like that. And so she comes out with a new collection 4 times a year. So she registers her collection 4 times a year with the Copyright Office. So that's the great thing about copyrights. So that's how you get one. You just keep doing what you're doing, keep writing your blog posts, and keep, if you want to register them with the Copyright Office, you can do that either individually or as a collection. So when is it the right time to register your work? Why would you register your work basically if you already have a copyright in something? You're afforded special privileges as a registrant. So for example, you could, if someone were to steal your work, you don't have to prove that, you don't have to prove how much money you lost. So for example, if you're a photographer and someone takes your images and puts them on their own blog and is booking weddings using your photographs, so people are thinking that these are the photographs that photographer, let's just call her Pam, like Pam stole your photographs and they're all over Pam's website. And so basically what would happen is if you didn't have a registration, you have to prove that you lost XYZ number of weddings to Pam, and that's equates to this much money, blah, 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 blah. So there's a lot of benefits to federal registration, and one of them includes being able to not have to prove those, what's called damages, how much money you lost to Pam. It's just automatic. They're called statutory damages. They're fixed amounts, and so that's, I know that sounds like really legal and profound and whatever and deep, but it's actually just a shortcut to getting your money back. So that's all that is. So there's a lot of advantages to registering your work. So if basically when you would register your work is when you have a significant collection of work. So maybe you wouldn't register like every single blog post. That would get expensive and tedious and whatever. So maybe you just register all your blog posts as a collection at the end of the year or something like that. So that's the right time to register your work. The other right time to register your work is if you find out that somebody is likely infringing your work. So if someone has ripped you off, to be and to get the benefit of those federal registration benefits, it's time to register your work at that point. Okay, so really quickly, what are some other forms of intellectual property? There's trade dress. So you may recognize like the classic example is if you guys have Waffle House. Maybe you don't have Waffle House, so I'll try to think of another one that's not so regional to Atlanta. They were started here. But the Waffle House is actually registered. It's a registered. The awnings of the Waffle House are actually registered as their trade dress. And so the other thing that's really exciting is that the Congress Congress and the Senate, they just approved a bill for trade secrets to now become a more, I guess you'd call it, a more legitimate area of law. So you're going to be able to register your trade secrets and prosecute people that take your trade secrets soon in a different way than you are now. So what a trade secret is a basically it's like the things that you have in place that keep your business running that other people don't know about. So if you're a calligrapher, who are your wholesalers? What is your process? What's your like employee management notebook look like? All of the things that it takes to run your business that you wouldn't necessarily just like share with the world. Those are your trade secrets. Like Coca-Cola doesn't have a patent or a copyright or anything like that on their recipe, and that's because it's protected by trade secret right now. And then finally, the other big area of intellectual property that doesn't really apply to us as creatives unless we have an invention is patents. And so patents are what you see on TV. It's like patent pending, whatever. It just means that you have an idea and you've sought registration for that idea and you're waiting to hear if the patent has been issued. So patents are a whole nother ball game, and I honestly don't think they're that applicable to what we're talking about here. So we're just going to mention them. Okay, why does intellectual property even matter? Okay, so think about it this way. Bakeries have bread that they sell. Fashion companies have clothes that they sell. You're a graphic designer. You don't have a physical product. You sell your ideas. You sell your work. I'm an attorney. I sell my contract templates. And that is my work product. Just like a baker bakes bread or cupcakes or whatever, and that's his work product. My work product is my intellectual property, my contract templates. And so that's why this matters to us as creatives. Emily's work product, those are her photographs. That is what she's offering. That's her bread to the world. Abigail does graphic design, so that's her bread to the world. And so just looking at your craft, your calligraphy, your photographs, whatever it is, your wedding planning expertise, whatever it is that is your field of knowledge, that's your intellectual property, and that is your little bread. Okay. What if somebody has stolen your stuff? This happens all the time. And a lot of people, I will just say, like, I don't think they do it intentionally. I really don't. I think that we live in a sharing economy and the law hasn't exactly caught up to, the Pinterest and the Instagram and the collaborative community that we exist in. But unfortunately, sometimes people take our photos or they take our copy and they do it in a way that maybe isn't so innocent. And so let's just talk about really quickly, if somebody has stolen your idea. So you have an idea for a business. I hate to tell you guys this, but ideas are not protected by any of the intellectual property that we talked about. So there's limited protection under patent law for ideas. Patents, by the way, start around $5,000. If you had a patentable idea, I would budget like $5,000 to $20,000 for that. But basically, things like business methods, that might be considered an idea. That's protected under patent law. But essentially, if somebody has taken your idea, your business idea, or your project idea, or something like that, go out and do it better than them. Do it in a different way than them. And that, I know that's not a legal answer, but that is the way that you protect that idea. That's the way that you move forward and that you conquer that sphere of whatever you want to call them, stealers, plagiarizers, infringers, I don't know. But that's honestly how you go out and you protect your idea. Now, if you have gone ahead and fixed that idea to something called a tangible medium, like in copyright law, you've taken that photograph, you've transferred that idea of the photo of whatever, the ribbon draped across the really pretty antique book, that is no longer an idea. That's actually a copyrighted image. And so if they have just gone ahead and they've recreated your exact photograph, or they have just copy pasted text off of your website or your blog, that's not an idea. That's actual copyrighted material. And that you can protect by sending them a cease and desist letter, or even just an email saying, this is my work. Maybe you weren't aware, but I have put a lot of thought and effort into this. This is part of my brand. Again, if it's like a trademark and they've designed a logo that looks just like yours, something like that, at that point, that's when it's appropriate to approach them, possibly with an attorney backing you up with a cease and desist letter. And we're going to talk a little bit more about what a cease and desist letter is in a minute, so hold on. But basically, that's when you can approach them and remind them gently that this is your idea, that this is your work, that this is your bread, and they're stealing your bread from you. So just like you wouldn't walk out of the store with a pair of jeans and not pay for it, they shouldn't walk out of your website with all of your copy or a photograph or something like that and not have to pay for that. So the other thing that we run into a lot is, have we accidentally stolen someone else's work? And like I said, the law hasn't exactly caught up to our sharing community, creative, collaborative economy that we're working in today. But, what if you go on Instagram and you accidentally steal someone else's work? Like, what if you use someone's photo without their permission? Or what if you go to Pinterest, or you pin a pin from someone else's blog and it's actually copyrighted material and they have a problem with it? Well, at that point, if it's online, they can submit something to Google or to Pinterest or something like that, and it's called a Digital Millennial Copyright Act notice, and it's a DMCA takedown. You may have heard of it. You may have even gotten an email from Pinterest that says, hey, by the way, one of your pins was deleted because it was actually probably infringing. So the way to deal with it if you accidentally steal someone's work is to immediately take whatever it is that you've taken, either on purpose or accidentally, down once you're aware of the fact that it belongs to someone else, and then ask them for permission. So, on Instagram, and I'm totally guilty of taking a photo of Abigail and Emily to promote today's talk, but I should have asked them for permission first and then given credit to that photographer. So that's one of the things, that's one of the ways that we can help prevent this. And I'm usually really good about that, but this morning I don't know what happened. So yeah, asking for permission, and if they grant you permission, or if they maybe come back to you and say, sure, you can use my photographs, just pay me this fee, they've then granted you a license, and then you can continue to use those photographs. So for example, on my Instagram, you'll see a lot of photos from other photographers, and those photographers have given me permission to use those images on my Instagram. So, you don't need to write like a long-winded response, just take it down, no big deal, and then ask for permission. If they grant it, hopefully they will. That's kind of the place that we live in. Great, and if they don't, you may have to pay for it, or you may just have to figure out another way to present that kind of work. So maybe you find the photos from another source, or you come up with your own copy or something like that. Okay, so the cease and desist letter. I get asked to write cease and desist letters all the time. I will say that just because of the nature of my work, I won't actually do this on behalf of a client, but I'm happy to refer you if this is a serious situation where someone has taken your bread, or taken your photos or your copy. A cease and desist letter, all it is an attorney drafts a really fancy, formal-looking letter, and it's basically the prequel to a lawsuit. So it's maybe not such a nice way, but it is a nicer way to learn that you may be infringing, or that someone else is infringing, or potentially infringing on your stuff, or that you are potentially infringing on someone else's stuff. And that's because a cease and desist letter actually isn't legally binding. All it is someone or you are telling someone that, hey, I know that you are using my stuff, and you need to stop using it or pay me a licensing fee. And we're going to talk about licensing too. So basically, that's what a cease and desist letter is. All they mean is that someone is aware, or you are aware of someone else using your stuff, and you're asking them politely to stop before you sue them. And it's typically a lawyer that sends them. It doesn't have to be an attorney. And then after you receive a cease and desist letter, not every cease and desist letter is, some of them are more what I would call bullying. So they may not actually be legitimate. So it's a good idea once you receive a cease and desist letter to go ahead and take whatever content that you're alleged to have taken down, after consulting an attorney and seeing if that's like the best course of action for you, because you may not have to take it down. It may actually be your property and this person is just being a bully. So it's a good idea to get in touch with an attorney and just see if this is a legitimate letter, this is a legitimate law firm, if you actually think there's a risk of being at fault for infringement, things like that. So not a big deal. I think if you're doing business with, I think if you're in business for long enough, you're going to get a cease and desist letter of some form, even if it's not legitimate, even if you've come up with your own completely original content. Maybe somebody just thinks that they can send you one for whatever reason. But again, they're not legally binding. So just if you have the wherewithal, go ahead and find an attorney to look at whatever letter that you receive and give you some advice on whether you should go ahead and take the material down, or if you're probably okay. And in that case, the attorney, I'm sure, will write a little response for you. So that's what happens. And if you really are potentially infringing and you don't take that content down, what happens next is that you could be served with a lawsuit. And that could be quite expensive. So I just know from personal experience here in Atlanta, I know the attorney that represents BMI, which is I forget what the what the acronym stands for, but basically BMI and ASCAP are the licensing authorities for all the music that you hear on the radio. And so what they would do is, and I'm not saying this is a good thing, I'm just giving the facts. What they would do is they would go to small little mom and pop bars, and they would sit there and they just write down the name of every single song that they knew this restaurant wasn't paying for. And then they would send them a cease and desist letter if they were being nice, or if they weren't being nice, they would just ask for statutory damages, which were quite expensive. So basically, that's why a cease and desist letter is sent. And that's what happens next if you don't answer the letter, or if you don't take the potentially infringing material down. Just a little side note, people ask me all the time, is this infringing? Is this plagiarism? Is this whatever? The person, or I should say the only entity that can decide if something is actually infringing is a court of law. So that's a really expensive, long, drawn-out process. So if you feel like something may be potentially infringing, it may be time to take it down and, like I said, come up with your own original content. So that doesn't, again, ideas are not protected under copyright law. So that may mean you come up with your own version of whatever it is that you already had on your website. You take your own photo, you write your own blog posts, about the same topic, something like that. Okay, this is another one that I get all the time. Is it ever okay to use someone else's quote, picture, or other copyrighted material? So we've talked about what a copyright is. We've talked about what's protected under copyright law. And the answer is sometimes it is. If you haven't picked up by now, trademark and copyright law, intellectual property in general, is incredibly fact-specific. So it would be, I couldn't tell you like yes or no, definitely one way or the other, but here are some of the things that we consider as attorneys when we're looking at whether we think something may be infringing. So parody is protected under copyright and trademark law. So for example, one of the companies I used to work at had a very famous animal trademarked, and Family Guy came up with an evil version of that animal, and it was very obvious that they were making fun of the whole corporation and things like that, and unfortunately there wasn't much we could do with them, or send them. We couldn't even send them a letter really, because it was a parody of our trademark character. So parody is protected, so that's why you see some like really funny videos, or like Weird Al makes videos all the time of very copyright protected songs and things like that. You can also bypass this kind of, you can also bypass this and use a quote or an image or something like that with permission. And so, like I said before, permission may just be someone saying, yeah, go for it, or they may actually ask you to license that content, which just means that you pay them a fee in return for the access to that content. Sometimes it's okay to use a really small sampling of a large work. I'd say unless it's Disney. Disney is a pretty scary one. They're notorious for never backing down from a lawsuit. But yeah, generally speaking, it may be okay to use a very small sampling of a larger work. So for example, if you're using a 3-word phrase from a 2-hour movie, is that okay? It's going to be really fact dependent, but generally speaking, that probably will be okay. So the other thing that I forgot to put on here is works. I think it's I'm going to forget the year in my head. I think it's works created in 1919 or before. At this point, are considered in the public domain. So those works are accessible to you. So for example, like Shakespeare or something like that, that's really old. You can quote that, and that's work that's considered not protected under copyright law anymore. By the way, copyrights last for the life of the author plus 70 years. So your copyright lasts a long time.
I have a quick question.
Yeah, go for it.
I saw this come up in a thread, in a Facebook group thread the other day. What about like calligraphists who use the line of a popular song, current song?
Yeah, so that's a great question. I mean, I can't say for sure. You never know for sure until you get that cease and desist letter or something like that, unless it's your original content. Or, you have somehow like crafted that line of the song into something else, or, another good way to look for things is everybody writing it. So there's a couple of things on mugs that I've seen everywhere. And, in that case, where no one is being prosecuted by whatever Disney or something like that, or I shouldn't say prosecuted, but no one's being sought after for a copyright infringement by Disney or something like that for a popular lyric or something like that, it's probably okay to use that. At that point, there's a certain amount of time. There's a doctrine called latches, which bars recovery after a certain amount of time in these intellectual property things. So yeah, if it's been like 10 years and everybody's been using that song lyric, that's a pretty good indicator that you're fine to continue using it. But it's, like I said, it's really fact dependent. It's going to depend on the exact song lyric and who actually is the licensing authority, like if it is BMI or ASCAP or something like that. So unfortunately, I can't give like a yes or no answer. I would love to, but yeah, if it were me, I would probably just look and see, how often is this used? Is it used by a lot of other people? Is there anything out there, like who actually owns the song, and like how often do they go after people for using their song lyrics? So, like I said, it might be what's called ASCAP, ASCAP, or BMI, like boy, man, iguana. That are the licensing authorities that are policing those songs. So that, at that point, it may be appropriate to just kind of see, like, how often do they go after people like this? Can I do that? If it is a substantial part of your business and you are, whatever you're selling it on t-shirts, you're selling it on mugs, it's on everything. And the other thing is, think about, just use common sense. Like, are you using this for personal use? Are you making like a family reunion mug that's never going to get outside your family? In that case, like I get a lot of people that are really, really scared, and they're like, I don't know, I don't want to infringe on anybody's copyrights or trademarks, and I'm making this thing for my daughter's birthday party. I mean, in that case, unless you're inviting executives or like the legal team from BMI, it's probably fine. So just using common sense and making sure that you're not outright stealing someone's copyrighted work or their trademark, and that you've thought intentionally about the designs that you create or the words that you write down. So yeah, unfortunately I can't give you like a yes, go for it, as much as I would love to. So really quickly, because we're running out of time here, let's talk about licensing your work, because licensing can be a great source of passive income for you, and it can also be a great way to use work that, you know, if you wanted to use that song lyric and know that you're doing it legally, you could license that work somehow. So what that means is that in exchange for using that song lyric, or in exchange for using a picture on your website, like for example, Emily sells photographs to her clients, and Abigail sells graphic design to her clients. Well, they still own the copyright in the designs and the photographs that they keep, unless they're assigning that copyright to their clients. And what they're instead doing is, and I haven't looked at their contracts with their clients, so I have no idea. I'm just using them as an example. So unless they're outright assigning that copyright to their clients, they actually are just granting their clients a license to use that work. So for example, if let's just say Abigail created a whole suite of graphic design for one client for you know, her poodle's grooming business, and then that client a year later she decides to open up a calligraphy business, she can't then, her license may not extend to that new business. She may have to get a new license from Abigail to use those graphics, or something like that. So a good example of this for creatives and photographers especially is Creative Market. If you don't know about Creative Market, or Etsy or something like that, these are all online platforms that you can use to sell your photographs or your graphic design or something like that. And so if you haven't taken a look yet, I would go take a look there and look, because they actually give you an option to buy a commercial or an extended license. You may see this in someone's store. And so these are the same things, an extended or a commercial license. And what that means is that, you know, where before maybe before I got serious about my business and I was just kind of making like a family newsletter and I was using whatever, Emily's pictures in my family newsletter. Well, now I'm actually using it in my business and it's going out to all the people in my newsletter. Maybe I'm overlaying a text graphic that sells something. And so then in that case, I need a license from her to keep using that photograph. And so again, where can you license your work? Creative Market, Etsy, all of these things are great ideas. If you want to license through like the surface pattern design client I have, she licenses through fabric companies. And then, you know, a lot of people are starting to license on mugs and on cell phone cases and things like that. So really the possibilities are endless. Okay, so just really quickly, some things to note about licensing agreements. And if you are getting into licensing, if it's not with like a huge, you know, conglomerate, like I wouldn't maybe consider Etsy or Creative Market a conglomerate, maybe they are now, but you know, obviously you have to abide by their terms. But if you're working with a smaller family-owned business or something like that, you can negotiate your royalty rates, you can negotiate the scope of your license, which is these second two things included in the scope of the license, basically how many rights are you giving away. And so it's a really good idea if you are licensing and it's not to like these big conglomerate things, to get an attorney involved and just read that licensing agreement. I guarantee that if they're a good attorney, they can figure out how to make up your legal fees for you in the rates that you're getting back from that licensing deal. So royalty rates. Royalty rates are typically somewhere between 2% and 5%. It depends on the industry. What that means is that if I am a cell phone maker and you have a graphic design that I want to put on my cell phone cases and sell, I pay you 2 to 5% depending on the rate that we negotiate per case that I sell. Exclusive versus non-exclusive, this is important. So if you give someone an exclusive license to something, then you can no longer give someone else another license to use that thing. So a non-exclusive license, if you grant that to me as the cell phone manufacturer or the cell phone case manufacturer, at that point, you know, you could also go maybe to, I don't know, Society 6 and license your designs there, or maybe you could go to, you know, like a fabric manufacturer and license your graphic design there, or something like that. And then there's a lot of other things to consider, but these are the top things that I would consider in your licensing agreement. So the other thing is to consider where your license extends to. So does it extend to countries like China where it can be mass produced, or does it extend only in the United States, or whatever? So those are all things that you can control. You can control the scope of that license through these provisions that you have in your licensing agreement.